Good afternoon. Okay, we are going to start today's class from where I stopped in last class, yeah? Class will start in 1 minute from now. We're going to look at the other alternatives, which will fall under unregistered design rights. So in 1 minute, we're going to continue where I stopped in last class. Okay, so I have a question. So let me just read the question, yeah? Yes, you can rewrite as that. Gives the registered proprietor an exclusive rights to use the design as long as the design that he has registered is what he is using. Okay, example, yeah, I give a very easy example. What section 7 sub 1 says is basically, if I am registering the design of the bottle, okay, I'm registering this design, this cap and everything, I'm registering this whole bottle. When I am producing it, the product that I am producing will have to be exactly the same of what I have registered for. So I cannot produce a design that is what I didn't register for. So if I registered this design, I will have to use this design. Anything that works with this design. So I have to copy this design. I have to do whatever I can, just follow exactly the same. Okay, that is what section 7 sub 1 says. As long as my design, when an informed user is looking at, he doesn't feel that this is not the design that I registered for. Okay, why it has to mention that any design which does not produce an informed. So that is what section 7 sub 1 says. If I am registering this design, whatever that I am going to do, whatever that I am going to produce, I have exclusive rights only to the design that I have registered. So whatever proprietor registers that I have obtained for this design, this is the only thing that I can use. I cannot produce any other design other than what I have registered for. So if immaterial details, yes, can, as long as it doesn't give the informed user an overall impression that why did I register for something but I came out with something else, then cannot. But when the informed user look at it, okay, this is what she registered, this is what she did. Okay, but if there's an immaterial detail, doesn't really matter, as long as when an overall impression is there, when the informed user look at both of it and the informed user feel like there is no differences of what I have registered and what I have produced, then it's fine, there's no infringement. Yes, you can have exclusive rights, though if you can prove that the material or the design that you have changed is immaterial, doesn't give the informed user an overall impression, overall different impression. Similar design, which is of course only immaterial details. Okay, like something that, okay, just say, because when I register this design, right, so just say that the lining here, okay, maybe not it's a bit different, slightly different. Okay, make sure that this immaterial design is not of what is going to give a different visual impact. If it's very minor, very small, you can't even see, then can. If it is something of a major, then you are not allowed to do so. Make sure the differences of what you have registered, because when we talk about registered design, right, there are going to be some changes that are going to happen. Just say example, I am coming up with this bottle. This is the design that I'm going to give. Just say while producing this design, something goes wrong. Just say like the painting, maybe if when I register that is a circle here, but when it comes to printing, when it comes to production, the circle was excluded. See, I registered for something which has a circle, but when printing, it's excluded. So when an informed user is looking at both of it and he thinks that, oh, it is still the same, it doesn't give a visual impression that the design that I have registered for and the design that I have produced is different. As long as it doesn't give, it is fine. But if it gives a different visual impression, if you can show that there is a visual differences in visual impression, then what will happen is automatically there is an infringement. Okay, so this is where we stopped in last class. So I told you in last class, when I say last class, it's yesterday's class. So we spoke about registered design, right? So I told you today we are going to look at unregistered design. Just a very quick recap. When we look at registered design, we look at two ways to register a design. One is either by domestic legislation of UK, another one is through OHIM. So OHIM is EU. So I told you when you want to choose between domestic or OHIM, you look at the nature of your product. If you feel your product is going to be something that is going to be marketable outside of UK, then myself you choose OHIM. But if you feel that no, my product is just going to stay in UK, I am a very small business person, then you just choose domestic regulation. Okay. The other thing that I am going to look at is unregistered design rights. So copyright is something that can also fall within unregistered design rights. Okay, let me tell you why. So now there is three ways that you can obtain an automatic design right. When I say use the word automatic, which means that I have created a design, but I failed to actually register my design. So because I created my design, I failed to register my design. That doesn't mean that I don't have rights on the design that I have created. This all reflects back to the reason why we have IP law. Okay, why we have IP law is purely because we feel that one person have put in their hard work, has created a design, and we should actually protect them. Okay, similarly, that is why we still have unregistered design rights. Okay, so when we talk about unregistered design rights, we have three ways to get your design protected, even though you don't go through the whole process of registering your design. Of course, when we speak about these three processes, the advantages will always lie within the registered design rights. Why? Because you have a longer term of protection. So when we look at registered design rights, you usually have 25 years. Remember, I said 5 years once, and you can renew it up to 4 years. So you have 25 years in total. So 5 years, up to 4 years, you can renew 5, 5, 5, 5. You have 25 years. When we look at unregistered design rights, don't look at copyright yet, yeah? Unregistered design rights, if you have marketed your product, you will usually get 10 years only. If you have not marketed, then you will get 15 years of protection. So 25 and 15 if you have marketed. You see there's a 10 years differences there. And when we look at if you have marketed, you only get 10 years. So this is why registered design rights is always better. The other way or the other alternative is what we call as the copyright. So under copyright, you can also protect the appearance of your article. Okay, and when you are doing a problem question, it is very important that you begin your problem question by explaining copyright first. Okay, I repeat, when you are doing a problem question, it is very important that you begin your question by explaining of copyright first. Why? Because copyright has a longer term of protection compared to registered design and unregistered design. So now, of course, when you're doing a problem question, we are not talking about registered design here. We are going to focus on unregistered design, okay? But when you look at an overall protection, copyright has a longer nature of protection. So it is always the lifeline of the author plus 70 years is the protection that you get as an alternative under copyright protection. So what is copyright protection? I am sure you have you have attended Mr. Sarah's class on copyright. So here, when you want to actually suffice under copyright protection as an alternative for design rights, you must first ensure that your article falls within the definition of section 1 sub 1 of the CDPA. So if you can actually suffice under section 1 sub 1 of the CDPA saying that your product or your article is under copyright, then you move to section 4 of CDPA. So I am not going to talk about section 1 of CDPA because I am sure you must be aware of section 1 already because you completed copyright lecture. Now, what is section 51? Section 51 basically works as a defense. So if you see, I have highlighted here, it is not an infringement, is what section 51 sub 1 tells us. Okay, so let me repeat again. When we look at an alternative, copyright is something that you must discuss under unregistered design rights first, where you will have to show that the claimant will actually argue their case under copyright first. They will try to say that this is something that is protected under copyright. Why? This is purely because copyright gives you a longer nature of protection. Okay, of course, the author's life plus 70 years, that is a really long time. So all the claimants would want their proprietary rights to be longer than a shorter period of time. So this is what you will have to do. Now, so when do you use this as an alternative? So we know that a lot of sectors, example like jewelry, etc. Okay, we just talk about jewelry, fashion, and all these sectors. They are always changing as time. So when they're always changing as time, it is very difficult to stick with registered design right because you have to register all the time. It's not very easy thing to do. So the claimants will prefer to actually rely on copyright. And what we are going to look at now is how to actually fall within the definition of copyright. And when we look at copyright or falling within the definition of copyright is where we look at section 4 of the CDPA. Section 4 of the CDPA actually recognizes 3D and 2D. Okay, so if you see the next slide, okay, Section 4, if you look at your CDPA, you can look at Section 4 where this copyright protects graphic work, protects irrespective of artistic quality, includes drawing, engraving, etching, and all this. So this is all under 2D. When we look at 2D, 2D is basically very less confusing compared to 3D. Sculpture and work of artistic craftsmanship is something that is very, very examinable in your problem question. Okay. When we talk about graphic works, what fall within graphic works? Do you know chart, diagrams? All these will fall within graphic work. So if you have any sort of chart, any sort of diagram, any sort of maps, all these can be classified as graphic work. And when we look at drawing, Drawing actually has the least threshold for protection. Why? This is because any single line on a paper can be considered as a drawing. Okay, just say you have a paper, you have a single line on your paper that can be considered as drawing. And when we talk about engraving, okay, you know plastic frisbee. I'm sure you all know what is a frisbee, right? Where you throw and then it comes back to you. And engraving on the plastic frisbee can be considered as copyright protection, can be considered as design copyright. You know why? Because you know when you have a frisbee, yeah, just an example, this is a frisbee. So on top of the frisbee, you will have like design, like a pattern. Okay, this pattern can be can be classified as copyright protection. Okay, other than that, when we look at etching, you know what is car mat? You know, you put when you drive the car, I'm sure down the car you always have a car mat, right? That car mat, the patterns on the car mats were considered as etching under copyright. Okay, so these are all example of 2D matters, 2D issues. Okay, so all these drawing that fall within 2Ds would be considered as an alternative. Okay, and then when we look at 3D, we have sculptures. Okay, when we look at sculptures, what is the most important thing is it has to be a functional item. Okay, so that is what sculptures actually talk about. Sculpture tells us that we need to show this is a functional item. Anything that is not functional, which means that purely utilitarian theory, purely only going to be beneficial for the public, but it doesn't have a function, that cannot be a sculpture. Just say example, I come up with a costume play. Okay, I'm sure what all of you all know what is a costume play, right? So if I come up with a costume play, you know, the Batman, Spider-Man, Superman, all of them have their costume play, right? This sort of costume play, it comes like a sculpture, like I'm going to make it into a sculpture. This sculpture will not be considered as a sculpture because it's not a functional item. It is just purely going to be beneficial for the public. Beneficial as in that it doesn't have a function to be beneficial. So sculpture and work of artistic craftsmanship is something that is a bit more confusing in nature, but we look at that later. Okay, so for now you must remember that all these, okay, graphic, drawing, plan, diagram, maps, all these can be considered as an alternative mean of protection for design rights. Okay, anything that has design, anything that can be protected under copyright would be a better option for the claimant because you will have a longer term of protection. Okay, so section 51 of the CDPA tells us that the design, meaning any design or aspects of the shape or configuration, whether internal or external, while the part of the article on other than surface decoration. So what I want to tell you here is shape or configuration is something that is very important that we are going to discuss. Okay, other than that, design document. What is a design document? Any sort of recording. So I will tell you, give an example. You will see this in problem questions. Okay, where when you have two parties to the question or more than two, this party goes and tell the other party, you know, this is my idea, and the other party writes it down or records the design. And this recording of the design can be in any form. It can either be I am drawing the design, okay, while you are telling me, while this person party X is telling me, I am either drawing the design, or I am writing a description on, oh, how, what, where I should put the pocket at the back, I should put the straps in front, I should add a red color symbol to the design. All these form of recording, even if I take a picture or I store it in the computer, all these would suffice to design document. Okay, and all this design document is what, if you want to suffice for copyright, you will actually have to show that there is some sort of recording under the design document. Okay, and then coming back to section 51, okay, coming back to the very first slide, this is a purely defense. Now, if I have actually, so remember in section 51 sub 1 says that it is not an infringement of any copyright in design document or model recording or embodying a design for anything other than an artistic work or a type of typeface to make an article to the design or to copy an article made to the design. So what does this tell? Why is this actually a defense? Now, if I have recorded a design, someone tells me and I have recorded it, this will not purely be an infringement. So you see the very first line here that I have highlighted, it is not an infringement of any copyright in design document. Okay, so this is the key points that we need to remember. That is why I'm saying section 51 sub 1 purely works as a defense. Okay. Does it mean that no copyright protection for any design document or model? Yes, artistic work. Yes, there is no any copyright protection for any design document or model other than artistic work. So here, what you need to prove is artistic work. So this artistic work is where we look at section 4 sub 2. Where it's either a 2D dimension or a 3D dimension. Either it's an so these are considered to be artistic work, graphic work. Like I told you, chart, diagram, maps, and all these are considered to be artistic work. You must show that there is actually an artistic work. And this artistic work is where you have to show that they have done something, an intention to make it an artistic work. Yes, only design of an artistic work could get copyright protection. That is why this is an alternative. But this alternative is not very easily established if you see, okay? But this is an alternative if you can establish. So that is why I say claimants will always have to rely on this copyright first before going to unregistered. If they have not registered their design, what they'll have to do is they will rely on copyright first to prove that this is an artistic work. Okay, so and this section 4 is what explains to us about what is an artistic work. Any sort of 2D dimensional work, which includes graphic, drawing, engraving, etching, all this is considered as artistic work. Like I told you, remember the under engraving, plastic frisbee, you draw on top the plastic frisbee, you have shapes, this can be considered as artistic work. Okay, car mat that you put in your car, right? Under your car, you have it, I mean, under this, where you put your legs to press the pedal of accelerators, right? So that car mats, the design on that is considered to be an artistic work, okay? But 2D dimensional, very least question in problem question. What we, of course, we always focus on is 3D dimensional work. 3D dimensional work is where we look at sculptures and we look at work of artistic craftsmanship. So artistic craftsmanship is more confusing. But let's go there, okay? Shape or configuration. So I told you that design document is actually where any sort of effort taken by the designer to record it would be considered as a design document. Where when we talk about recording, it can be any form of recording here. It can either be I am drawing it out, okay? Just say I'm sketching this whole thing out. Okay, that can be a form of recording. If I am writing it in description form, where should I put what should be added where, that can be also a form of recording. Okay, and then if I'm taking a picture, if I'm putting this data in the computer or any sort of recording will be considered as design document. So in the case of Mackie design, the courts have held that design document does not only mean drawing. So that's why I told you, right? It's not always drawing, even writing, even sketching, even typing it out in written words or keeping in data storage. Everything can be considered as design document. Not necessarily looking at the literal meaning of drawing is what the courts actually look at. Any sort of configuration. And in the case of Mackie design, the court held even a circuit diagram. Remember, I told you drawing includes diagram, includes chart, includes planning. All these maps, all these can be considered as a design document. And the courts don't look at the literal meaning of drawing here. So because in our mind, when we talk about drawing, is drawing, right? No, the courts don't take a literal interpretation when it comes to design documents. The court will often look at what sort of things or any sort of effort taken here to actually record the whole thing. Okay. In the case of Lambetta and Teddy Smith, this is one case that I want to talk about. In the case of Lambetta and Teddy Smith, this is about the choices of color. So I'll tell you. Here what happened is this party actually came up with a t-shirt. Okay, Lambetta came up with a t-shirt. It's not really a tank top, but it's like a short kind of t-shirt. And the reason why they actually sued was because they felt that Teddy Smith copied the color of their t-shirt. So these Lambetta people, they came up with a retrospective theme. Okay, retrospective theme, they have very different color of t-shirts. Okay, so this Teddy Smith, after 2 years of first Lambetta came up with a t-shirt with the color and with the retrospective theme color t-shirt. And 2 years later, Teddy Smith came up with something very similar. So Lambetta said that at that point of time that, hey, look, this is the color that actually I have protected, a color that I have chosen. So remember, I told you at the very initial, claimants will always try to claim under copyright first. So similarly happened in the case of Lambetta, and here in Lambetta, the court, Lambetta, they tried to rely on copyright, but here specifically relying on the color of the t-shirt, because their term of t-shirt was very retrospective theme. So they had like a bluish, I can't remember, it's like a bluish green kind of color, which according to them is a very retrospective theme. So when Teddy Smith came up with something very similar 2 years later, Lambetta found that they are actually infringing my design rights, and they tried to rely on design rights, saying that the color is actually a surface decoration. This is what exactly they said. But the courts held that, look, color will not fall under shape or configuration. So remember, when we spoke about design under copyright, you must show under section 51 sub 3, you must show that this design is any aspect of shape or configuration. So configuration is where we talk about internal and external. Okay, this can be designed. So like, circuit diagrams, you put that I'm sure, like how the electric system works, right? Like all these wires and all this can be used under design right. But colors is not under design right for copyright. Under copyright, no. But when we saw about registered design right, yes, can. Okay, so this is the differences here. If you are relying on copyright, according to the case of Lambetta, the courts failed to actually uphold the whole idea of colors to be classified under shape or configuration. Okay, so the courts are that now if you want to use color, if you did not register, it will fall under unregistered design rights, not under copyright. So under Lambeta, under copyright, no protection was given because colors are not considered to be as a copyright. Okay. So artistic sculpture. So artistic sculpture is where I spoke about something that anything that is very in relation to something that sculpture. Okay, when we talk about sculpture, yeah, the courts always take an interpretation that sculpture should not be anything that does not have a function. Okay, I give you an example. So the example can be seen in the case of Lucasfilm. So I'm not sure if you guys have watched Star Wars. If you have, then you will know this helmet in Star Wars. It's called the Storm. Just give me a second. Stormtrooper helmet. Okay, so those, if you guys are Star Wars fan, you will know this Stormtrooper helmet. This Stormtrooper helmet is something that was created and was classified as a sculpture, or in the case of Lucasfilm, they were actually trying to classify or get right, saying that this helmet supposed to be getting a copyright protection under sculpture, because it's something that you have sculpted into one sort of design. Okay, you know how a helmet looks, right? And this helmet had certain design on it that was supposed of what the claimant was trying to say, that this supposed to get a protection under copyright. But the courts said that no, we are not going to give you copyright protection for this helmet purely because this doesn't have a function. This helmet is purely only for utilitarian theory, where when we speak about utilitarian theory, it is purely only going to be beneficial for the public, but doesn't have function. So when you want to establish under copyright, when you want to establish a design protection under copyright, you must always show that this sculpture that you have created is going to be very functional. If it's functional, yes, you can get copyright protection. In the case of Lucasfilm, the Star Troop helmet that the courts found, they found that this is not functional because this is purely a costume play. Costume play, yes, certain people are going to be happy about it. Certain Star Wars fan is going to be happy about it, but it doesn't really have a function to be used. When you don't have a function to use, then it cannot fall under sculpture. So this is the general interpretation or general rule that you must remember when you want to discuss a design to be a sculpture. You must always show that this design has a function. And we have Manje, who have actually explained on the guidance factor that you must look at when you want to determine if this design will fall within sculpture. Okay, again, I'm telling you why claimants will always love to prove copyright first, purely because you have a longer term of protection. So claimants, or in any problem question you do, you must always remember that it is important to show that this design will fall within sculpture. Correct. Artistic work should not be associated with functionality, but when it comes to sculpture, it is different. The courts look for functionality, and this functionality, not necessarily functionality. I will give you an example. Just say I am coming up with a vase. Okay, because I remember when I spoke about registered designer, I say it doesn't care about how it functions because we are talking about the appearance, right? But when you are trying to establish under copyright, trying to say that this design, this article is basically a sculpture. I'll tell you what. Now I'm coming up with a vase. So all of you all know what is a vase, right? So this vase, I am actually, you know what is a prototype vase, where I have designs on my vase, I have engraved my vase, I have made my vase look beautiful. But when I am thinking that this is a vase, of course, this vase must have a function, right? What function? To store water, so I can put my plants inside. This sort of function must be needed to prove that this is a sculpture. Okay, this is what exactly sculpture means. Sculpture meaning you must show that this vase, okay, because when I come up with a vase, it wouldn't make sense that the vase cannot store water. I cannot put my plants. I cannot do anything with the vase. Doesn't have a function. Like the stormtrooper helmet, it doesn't really have a function. Copyright protection will only be given to sculpture if you can prove that it has a design and it has a function. If the stormtrooper helmet actually had a function, example, if that helmet was something that can be used for riding bike, protect your head, you know, from accident and etc., possibly the courts would take this into account as a sculpture. But the reason why the courts didn't take into account stormtrooper helmet as a sculpture, because they found that this stormtrooper helmet was created merely for the purpose of costume play, which is not in function. So remember when I spoke about 3D, right? When I spoke about 3D dimension, when I spoke about sculpture, I told you that this you have to show a functionality. And this functionality is not necessary. This is the reason why I came out with this. Just like the vase I told you, or just like this vase, okay, just example, this vase, I am designing this vase and I am trying to say that this vase is a sculpture. The next thing the court would only satisfy if you can show this vase has a benefit. What sort of benefit? Example, I can hold water. Then the courts will give you copyright protection. If the courts don't find any reasons for you having this vase, just say it doesn't make sense. The vase cannot store water, cannot put fruits or cannot put flowers inside. The courts will have that this is not under sculpture. So the courts are very, very careful when they actually give you a protection under copyright, purely because you have a very long nature of protecting, right? So they cannot give you a very long protection when it doesn't have a function. Why would I give you a protection for something that doesn't have function? This is the perception of the courts, okay? Only when it comes to sculpture, okay? Just like if you see, okay, the A to I is what you ask yourself if this design would actually be considered as a sculpture or not. So you ask yourself these questions, you ask yourself and see what is the normal used word of sculpture. So when I tell you what is a sculpture, you will be thinking something that I have sculpted into, okay? Just say it's a tree. I have sculpted the tree. The next thing you look at, what is the purpose of this tree? To provide oxygen for people, to give people some benefit. Example, yeah, it has to be associated with function. Okay, so that is where you look at A to I to decide whether this design that you want to rely on an alternative of copyright, whether this design will fit within the definition of sculpture. And we have Man J in the case of Lucasfilm, who have explained what are the guidelines that you must take into account while deciding if your design will fall within a sculpture. Okay, so the next thing is, when we look at sculpture, is just not something that you see in the art galleries, okay? Not necessarily, you know, the first thing you may think in your mind is, you know, when you go and when you look at Paris, Okay, you know, Paris has a lot of sculptures. They have a lot of man-made sculptures where they design things. It's not merely just that. We look beyond that. Like I told you, a vase. A vase can be considered as a sculpture if that vase has a right or has a function. Example, if you, yes, under copyright and design right of copyright is different. Yes, correct. Correct, Christopher. So the general rule, when we look at artistic function, right, doesn't have to look at functionality. Remember, I talk about RDA when we're going to look at unregistered right. We don't care about the functionality because design rights is all about appearance. But the only differences here is when it comes to sculpture. Sculpture, yes, you must look at functionality. If there is functionality, then yes, the courts will grant you a sculpture. This is the reason why I say purely for the purpose that I am giving you a very long term of protection here. When I'm giving a very long term of protection, the age of the author plus the time that the deadline of the author and 70 years plus that, very long term, if I'm going to give you copyright protection for something that is not of function, what is the use? How is it going to be beneficial? So that is why the courts feel that if I am going to give you an alternative protection under copyright for design right, you must show me functionality to satisfy the courts on why I should give you copyright protection. This is the idea underlying behind this. Okay, so what is of course I said when we look at sculpture, not necessarily to think about the literal meaning of sculpture where what is in the art gallery. Not only that, anything that is above that also can be an sculpture. Examples you can see in problem question, maybe a bag can be considered as a sculpture. So when you are arguing or when you are explaining about sculpture, please be reminded that do not look at the literal interpretation of sculpture, because sculpture can be anything beyond what you look in the art gallery or what you even see or think in your mind where you're designing a people or sculpting a people. Okay, it is far behind that. And not necessarily it has to be a 3D representation. Okay, so when you are deciding whether your design suffice for sculpture, not necessary you must show that your design only if it's a 3D design you can fall within a sculpture. Even if it's not a 3D design, you can try to fit within sculpture. So that is why I'm reminding you again, every time when you discuss an unregistered design rights question, a problem question, always be reminded that it is important for you to actually look at, I mean, when you're discussing about an unregistered design right question, very important for you to first discuss on copyright, because not only sculpture or anything that you think is of functionality and anything that has a visual appeal, like when I am creating this vase, the intention or the reason I'm creating this is because I want to make sure this vase look very beautiful, but at the same time it will have to have a function. So both must be together. So example, when I am coming up with this vase, I am thinking that, oh, okay, I am going to sculpt this vase so people will look at it and think, wow, this is such a beautiful vase. This is such a beautiful sculpture. At the same time, this vase actually has a function behind it where I can store water in it. Okay, this is not a vase, this is a bottle, but example, I can store water in it. So when you have a function and when I have the intention to give you a very good visual appeal, then automatically it will fall under sculpture. So again, I'm reminding you why this stormtrooper helmet was not considered to be a sculpture under Lucasfilm was purely because it had a visual appeal, but it didn't have a function. Okay, so if you see point number H, Okay, a pile of brick at the Tate Modena, that would be considered as a sculpture because it has a design and it has a function behind it. Okay, next thing, if a pile of brick in front of your house, what function is going to give you? It's not going to be a sculpture. It's purely going to be used to build your house. So same material, you see bricks, yeah, in front of the same pile of bricks that is used in the Tate Modena can be considered as a sculpture. But if the same pile of brick in front of your house, which functions very separately, see two piles of brick, one functions to build your house, one functions as a sculpture, one will be protected, one will not be protected. So when you want to know whether your design can be protected or not, what you need to look at is basically what is the function of this sculpture. Okay, so if this function of the sculpture is basically to have a good benefit, most likely your design can fall within sculpture. The one only thing that I want to remind students always is don't stick to the literal meaning of sculpture. If you're continuing to stick with the literal meaning of sculpture, you'll find you a bit difficult to understand. Always think that sculpture can be anything that the creator came out with purely because wants to make sure it has a visual appeal. It gives a very proper looks or rights of that particular thing. Okay, that can be sufficient for sculpture. Okay, artistic craftsmanship. This is one very problematic area. Why would I say very problematic area? Because you can see artistic craftsmanship is actually a composite phrase. When we speak about artistic, what we think of? Eye appeal, visual appeal, very important. It has to be appealing. When we speak about craftsmanship, craftsmanship is purely people crafting it, and not necessarily, okay, I will tell you why, not necessarily the designer is going to sit down and craftman that particular design, right? Because we know that unlikely, very unlikely that the designer, most likely if it's just one piece, yes, of course, the designer will be sculpting it. But how if you're working in a company where you're producing a lot of sculpture? So not necessarily the designer is going to sit down and sculpt everything. We're going to have labors. Labors are going to do it. We're going to have workmanship. People are going to do it. So when you have two composite phrases in one article, one line here, artistic craftsmanship, very difficult to actually establish. Not difficult to establish, very confusing because it has two different definitions here. Artistic, eye appealing. Craftsmanship can be done by any skilled workers as well. Not necessarily you must show that it is done by person. I mean, not necessarily you must show that it is done by the designer himself. Okay, so this artistic workmanship is of course something that is a bit difficult to establish here. But in the case of Henscher, okay, Henscher and Resville, the court held that if you want to establish artistic workmanship, you must show both the requirements. You must show that it is an artistic work. Together with that, you must show that it is an artistic workmanship. You have to show that it's an artistic work, and together with it, you have to show workmanship. The next thing is workmanship is something that the courts have regarded as or decided that this workmanship can be done as a team. Not necessarily it has to be done by the designer himself. It can be done as a team. So now it makes the understanding a bit more clearer. Initially, when I spoke about artistic workmanship, it both two composite phrases. Two composite words have two different explanation. When you put it together as a phrase, it's very difficult to understand. So in the case of Hansher, they have established that you must show that you have an artistic. When we speak about artistic, you must show that when I am creating this design, I had an intention to make sure that this is artistic in nature. Example again, I'm going to use where I came up with this vase. I am going to make sure that this vase has an artistic way of nature. It has to look beautiful. It has to look nice. At the same time, not necessarily the designer is what going to sit down and do all the vase that he is going to sell. It can be even his workers doing it. As long as it's done with a team, the courts will accept the fact that this is a workmanship. Okay, so remember, it is also not important to show that it is produced in a mass production, which means that it doesn't have to show this is an industrial thing. As long as maybe you have done one and then you have other people there is going to do a few more others, the courts will actually still accept the fact that this is an artistic workmanship. Okay. Okay, so this prototype vase is what we look at. So this prototype vase is what I told you. If you actually Google for prototype vase, or if you go and look back what a prototype vase is basically a vase that has a design on it. The designer will draw designs on the vase, and this is what the courts will look at, whether it has a functionality, whether this is an artistic craftsmanship, and the court says that this prototype vase can be an artistic craftsmanship. Okay, but at the same time, courts are very scared to give you copyright very soon, because the courts feel that if we give you, I will automatically limit the protection. Why? Because now future people who wants to come up with similar design will find it a bit difficult, because I have already got the design there. Okay, so however, this is what the courts often look at. The first thing the courts look at is whether it falls under sculpture or not. If it falls under sculpture, you will have to show this. Okay, this guidelines that has been given by Manjay here to show whether this has functionality, whether it's a sculpture or not. And then the next thing, if it's not a sculpture, then you have to show it is an artistic workmanship. These two definitions will fall under 3D dimensional work of copyright protection. So this alternative of copyright protection is what we can see, or sorry, this copyright protection is basically an alternative if you fail to register your design. So if you fail to register your design, you can use copyright protection as an alternative, and you will get a longer tenature. You will always have to first, so usually in problem question, you don't really see much of drawing, because drawing any single line on a paper can be considered as a drawing. What will always be considered, or what you will always have to explain, if whether this is a sculpture or whether it's a work of an artistic craftsmanship. This is the two things that is often examinable. And when we look at sculpture, always remember, sculpture is something that you will also have to affiliate with functionality. Just purely sculpture without a function, the courts will not accept that. And you will have to ask yourself these questions, whether your design will fit within a sculpture or it will not fit within the sculpture. The next thing is you look at artistic work, craftsmanship. So I told you artistic craftsmanship is two different things. Artistic is always, we look at eye appealing. Craftsmanship is always done by skilled workers. So these two different definitions put in one phrase, of course, is going to bring a lot of confusion. But the court have held that it's okay. It was resolved in Hensher that the court held that it's okay. as long as you have an intention to make it eye appealing, and if it is not done by you purely, if not done by the designer, if it's done by the team, it can be still taken into account as an artistic craftsmanship. Not necessarily you have to sit down and do everything by yourself, okay? Not necessarily, because it is irrelevant and it will not make sense that the designer will have to sit down and do everything in order to suffice under artistic craftsmanship. So this too is what the courts actually explain as an alternative under unregistered design rights. This is a very short thing. Actually, it's a very short. You just have to show whether it fit within design. Okay, you show under section 1 sub 1 first, and then you explain about whether it fall within 2D or 3D. 3D sculpture or workman, this is often what is been examinable. If at all you get drawing, engraving, etching, it's a bit easier to suffice the court to answer. Okay, then you will just have to show that whether sculpture, you have to ask yourself this question. And basically, when you look at artistic craftsmanship, you look at these two terms. So then this is, of course, a very short, usually you'll get like 1 page of answer, but you just have to show this first. In every problem question, you will have to explain on this first before moving to unregistered design rights. Of course, copyright is better. Why copyright is better? Because copyright gives you a longer term of protection. If design rights, it doesn't give you as long as copyright will give you. But if you have protected, it's easier to establish. Okay, so the other thing that you must think also, if I am going to rely on copyright, it is going to be difficult for me, because I will have to show the courts that this is a sculpture, this will fall within the functionality, this has a meaning, this has a benefit, and etc. But if I have registered, so I am assuming that you're asking me if registered design rights, of course, it's better because I don't have to establish anything. As long as I have registered this, I am using the same thing that I have registered for, easier to establish. Copyright is something that the claimant must argue here why you should be given the protection under copyright. Okay. The very next thing that we are going to look at is unregistered design rights. Okay, so when we look at unregistered design rights, okay, when we look at unregistered design rights has differences with registered design rights. Okay, what is the differences? I told you the term of protection. The next thing you can ask me back is, why do we actually have unregistered design rights? Okay, if you see here, why do we actually have unregistered design rights when we purely have a regulation which actually protects design rights? When the law has clearly tell you that I have a legislation to protect design rights, why should we still give way for unregistered design rights? Why, if someone failed to register their design, why should we give them protection still? Is the next question that we ask ourselves. Okay. Okay, fail to register meaning I never register my design. Okay, example that I came up with this pen, but I didn't register this pen. I didn't register under design right to say that this design of the pen belongs to me. I failed to do that. Okay, which means that the design was never registered, not rejected, but never registered. So why should we give protection to someone who failed to register their design rights, because purely we know that design rights is protected when you register. So this all comes back to the labor theory back, where John Locke has said, if I have a field of land, I have plowed the land and planted wheat, that wheat should be belonging to me because I have put in my sweat, my hard work and my skill to come up with the design. Similar concept was used in unregistered design rights. So unregistered design rights, the court held that the reason why we still protect unregistered design rights purely because these people, they have created this design out of their own skill. But just because they fail to register doesn't mean that they don't have rights to their design. So this is why the court still acknowledges unregistered design rights, because the courts feel that if someone fails doesn't mean that we should exclude them from protecting the design that they have created. So if you see slide number 1, this is the diagram that you must have in your mind always, because when you look at a problem question, first thing first, you have to identify whether it is registered or unregistered, which is mostly, of course, you're going to look at unregistered cases, okay? Unregistered meaning you will always have to first explain from copyright, because copyright gives you a longer ternature of protection, right? Explain on copyright first, then you go and look at unregistered law. And when we look at unregistered, we are mainly focusing on part 3 of the CDPA 1988 Act, which is the Copyright Design and Patent Act 1988 part 3, which solely gives reasons on why we should protect unregistered design, or solely tells us what are the designs that can be protected under unregistered design rights. Okay, so once you have established that, first when you look at unregistered, always remember copyright first. Speak about copyright, whether it falls within a sculpture, artistic craftsmanship, and etc. Then you move on to speak about unregistered under part 3 of the CDPA. Or you speak about community unregistered design rights. This is very similar in nature. It just mirrors the same principle. Just like how under RDA, I told you, under registered design rights, I told you, registered design rights or OHIM, it is the same, just that the renewal fee and etc. will be different. But the process, the qualification, everything will be the same. Similarly works with unregistered design rights. Unregistered design rights also works very closely connected to each other. So the CDPA and the community unregistered design rights work together. So that is why when you speak about unregistered design rights, you choose copyright and then unregistered design rights. So this is your structure of problem question. Okay. Now, I've explained to you why we still do have unregistered design rights protected, though we know that we have legislation clearly governing and telling that why we should actually, we have legislation that clearly governing and protecting design rights. So this is where Lambeta Clothing re-emphasized and said that, look, we are going to retain domestic unregistered design rights, but we are going to make some minor amendments to it. So remember, I told you part 3 of the CDPA mainly deals with unregistered design rights. So this is what Lambeta actually concluded and said. When the question arises whether we should have both or not, why we are making things more confusing and puzzling for a designer. Now he must be thinking, where am I to actually register my design? Or if I don't register, where I should actually claim infringement under? Why you are making this very complicated? Might as well just follow registered. And Lambeta said, no, we are actually going to acknowledge unregistered domestic design rights as well, purely because of what John Locke said. If someone has put in the effort, they have created a design, just because they fail to register doesn't mean that they are not the owner of the design. So they must be an owner of the design. So remember, I spoke about the advantages of registered design right compared to unregistered design right. So the advantages here will purely be the nature, the time frame of protection. So when we saw registered design right, longer time of protection, unregistered design rights, a shorter term of protection. If it is marketed, it is already out there in the market, then it is only 10 years from the date you have marketed that product. But if you have not marketed, then it is 15 years from then. Okay, so this is what the courts held. And remember, this unregistered design rights is actually an automatic protection. As long as you can show this is a design, an article, as long as you can show it has originality, as long as you can show it is in a common place, as long as you can show it has a design feel, as long as you can show it is not within the exclusion, then automatically you can get protection under unregistered design rights, though you fail to register. Okay, so I repeat, if we look at unregistered design rights, first you will have to show that this is a design or an article, then you will have to show originality, then you will have to show commonplace, then you will have to show design feel, and the next thing is you must show that these do not fall within the exclusion. If all these designs, so you have certain exclusion, certain things that the court feel like, I don't want to give you unregistered design rights. Okay, this is especially with spare parts. Okay, why spare parts here? Purely because the courts feel that if I give you protection for spare parts, what will happen is it will be very monopolized. Okay, example I'm giving you, yeah, I have a car. Okay, just say, you know, car has like filter and then the black oil, engine oil, and etc., right? These spare parts, okay, the filter of the car, which you will have to change during the service of your car, if I only allow your car, your example, let's just say Honda, or just say Mercedes. Okay, Mercedes has their own filter. But if I only allow Mercedes to create that spare part, that filter, other companies cannot create that spare part, what will happen? People who buy Mercedes car will have to only buy from Mercedes to replace the spare part, which will be very monopolized. Now, if Mercedes suddenly decide to increase the price, what will happen to all the Mercedes users? They got no choice because other spare parts cannot come up with this. So this is why the court said that if you fit within the exclusion, which you will see, okay, there's a few exclusion in the modes of construction, surface decoration, must fit, must match. All these are the exclusion. If your design fit within this, then you are excluded from unregistered design rights. This is purely because the courts don't want to allow monopolizing the whole system. Okay, otherwise people, consumers will feel very, very difficult, purely because only one company can produce that spare part. Okay, so this is what unregistered design rights is all about. They want to make sure that if you have put in your effort, it shouldn't be copied. Originality is very important. So we spoke about, you know what is independent creation. As long as you can show it's an independent creation, it is an originality. automatically you must show all these, yeah, show design, show originality, show commonplace, show design feel, and it's not within the exclusion, then automatically you can get unregistered design right. Though you didn't register your design, you can still get protection under unregistered design rights. Okay, so what is the criteria for protection? Okay, we look at the criteria for protection. There is a few very important section under the section 213 of the CDPA, where you will look at section 1 to section 7. All these are very important. Section 1, section 2, and section 4 speaks about design. What is design? How designs work about? Section 3 speaks about the exclusion. So once you are free, you can go back and look at the CDPA and read the statute by itself. Section 1, 2, and 4 speaks about what is a design. Okay. Section 3 speaks about the exclusion of design. It is very important for you to look at section 1 to section 7. So when you're free, just go and read back all the section to get a better understanding. So section 213 of CDPA, section 213 sub 2 of CDPA tells us that design means shape or configuration, internal or external. Please correct my spelling there. It's internal or external of the whole part or part made of an article. So those that I have bold, the shape or the configuration, article, all these are very important key points that you must remember. Okay, so we have the case of Farmer Bill. Okay, we don't have proper legislation to explain to us what is an article, but what we can know of the case law of Farmer Bill have explained to us that an article is basically the shape of the article. If this is the shape of the article, where it has like a straight line and then it moves, become narrower at the end, this is what we call the article. We don't have a legislation purely telling us what is an article, but according to Farmer Bill's case, Mamre LJ have defined shape, article as a shape of the article. How does it look? Remember back, what we are talking about here is basically, what we are explaining here is basically all about design, all about the shape. Okay, not the functionality, unless if you are relying under sculpture. Yes, sculpture, they look at the shape. Other than sculpture, sculpture, they look at the functionality. Other than sculpture, what the courts always ask yourself is basically what is the appearance, or how does it look like, is what matters the most when you talk about design. So we have the case of Mackie Design, have made our life more easier in explaining what is a shape. Mackie Design is a case. Mackie Design have actually explained to us that shape means any outwards appearance or external form. How it looks outwards. How does it look? Okay, it has like a straight line here and then getting narrower at the end. This is how it looks. Or more like the external form of this pen is what you will have to explain as shape. So shape, so remember all these bold things, the bold and underline keywords. These are very important in deciding unregistered design. Okay, so design under unregistered design, because if your design that you are trying to rely on does not fit within the definition of section 213 of 2, okay, does not fit within 213 sub 2 of the CDPA, then you cannot claim for unregistered design rights. So first of most, you must show that you are trying to actually claim for unregistered design rights under design. So this design is very important. And when we look at shape, this is what shape, anything that is of external. When we talk about configuration, what is configuration all about? Configuration is all about how you have arranged everything into a pattern. So you have various parts of an article, you have arranged them, configured them. So if you use the term configured, it will make you to understand things better. You have combined them together in an arrangement that looks more like a design. That is what configuration means. Okay, so not necessarily it has to be only a shape. Shape, yes, because when you look at the definition of design, it is the shape or configuration. So when we saw shape, we know Mackie designer have explained to us shape meaning any outwards appearance, correct? And then configuration is also what we know of arrangement of various parts where you have put them together and configured them into one part. So we have a few cases that have explained or made our life more easier to understand what configuration is. So we still have Mackie here, Mackie designer. This is the same case that have explained to us what is shape. So here under configuration, we know that any arrangement of any parts that have put in together as an article to each other to make it one design. Then if you have such, your design or your product or your article will automatically be under unregistered design rights. But just remember, not only showing design is important. You must show design, you must show originality, you must show commonplace, you must show design feel, and you must make sure that this is not within the exclusion. So showing or establishing unregistered design rights is not very easy as we think. So now, if you can, if you may, please go and get your design registered first. If you fail, then you rely on copyright. If you fail under copyright, then you rely on unregistered design rights. And if you want to rely on unregistered design rights, remember these 5 things are very, very important for you to discuss. Okay, you must discuss that your product or your article is within the definition of design. Where when we look at design, it can either be a shape, configuration, or an article. So configuration is what Mackie, Scholes, and Blockcase have defined to us. Even the properties of the materials can be considered as an configuration. So, you know, like the properties of the material, like it is an aluminium or it's anything. The properties of the material, or even in the case of block, you know, transparent glasses. 2 different transparent glasses, you put them together, that can be considered as a configuration. So anything that is combined together, 2 different things, you put them together, can be considered as a configuration. Other than that, we also have definition for article. So under Lambeta, the court said that if you want to show article, you must make sure that it is either flat or has 2-dimensional, even like a sheet of paper. Do you all know what is a doily? So, you know, this piece of paper that is used to separate, if you have bought biscuits together, you know, like cookies, or you have, when you go for an exclusive tea party, they usually put like a white sheet which has a dimension, like has a 2D design on the paper. It's always crafted. Or even when you just say example, when you fold a paper into 4 and then you cut the paper, when you open, it has like a design on the paper, that can be considered as an article. So according to Lambeta, even a doily can be considered as an article. Okay. In the case of Parker, the courts held that cases for mobile phone, you know, these cases that you use for mobile phone, this can be considered as a design. This can be considered as an article. Contact lenses. Okay, the court held that the shape of the contact lenses, actually, if you see the shape of the contact lenses, it is of a slight shape that can be also considered as an article. Okay, kitchen unit can be considered as an article, but the whole kitchen as itself cannot be considered as an article. So first of most, you must make sure the design that you are trying to protect under unregistered design rights is actually within these definitions. Okay, within either it's under definition of shape, configuration, or an article. So then we have section 3 sub 2 of the CDPA. Okay, where when it comes to design, you have to show it's either an article, either a configuration, or either an shape. The next question that you ask yourself is whether is there a need to make sure that this design actually have an artistic appeal, whether it has to have an artistic merit, or either it has to be of eye appeal. And this was clarified under section 213 sub 2 of the CDPA, saying that there is no a need to actually make sure that this design that you are trying to rely on has an artistic merit, which is very, very not like the copyright. Okay, so that is why under unregistered design rights, it doesn't really matter if it has an artistic merits or not. Like examples, spare parts. Yeah, this whole reasoning why unregistered design rights came into account is purely because of spare parts. Spare parts doesn't really have an eye appealing, like it's not to make the thing look beautiful. Okay, the reason why they have spare parts is to just replace parts, right? So that is why under design unregistered design right, it is not really necessary to actually make sure that it has a beautiful or artistic merits. Okay, as long as, okay, so if you see the next point there, using during normal use of the article, and it may possibly be invisible to the naked eye. So what do they mean by be invisible to the naked eye? This is basically an explanation of the CDPA. Yeah, what do they mean by invisible by the naked eye? Meaning some designs can be at the very corner of the particular a very corner of the particular design. Just say an article. Yeah, this is the article that you're trying to rely. This design is at the very corner, like you cannot see. Sometimes it's possibly invisible, you cannot even see that particular design is there. Okay, so even though you cannot see or you can see, doesn't really matter. Okay, what the courts have to tell you is, all that we are trying to help you here is not to monopolize the market. Okay, we don't want you to allow someone to monopolize the market. We don't want you to be what is the proper word to use here? We don't want you to be an affected person of the monopoly that is going to happen purely because of spare parts, like what I told you earlier. Like if I'm coming up with the design, if I don't allow other companies to come up with the same spare part, what is going to happen? Everybody is going to take advantage of it, and they're going to increase the spare part price. So if you want to drive their car, you must be willing to pay the price for their spare part, which is unreliable or doesn't make sense here. Okay, so this is why the courts actually came up with unregistered design rights, purely because they feel that we should allow people to get their rights protected. So these all fall within the definition if you want to get your design to be protected. Under OSCULA, okay, OSCULA signs and aspect protection, this is something that is very, very important. So I want to explain a story first before we look into very detail of OSCULA. What is the story that I want to tell you here is, prior to this CDPA, right? This CDPA was actually was actually amended by the Intellectual Property Act 2014. Okay, so what happened prior to it being amended? They say, okay, if you look at section 2(1) sub 3, it can either be the whole part or a part of an article. So if you see this section here, 213, right, it can either be of the whole part or part of an article. Okay, this is something that I want to explain under the case of Oscula Science. Why? Prior to this, they said that if we allow whole part or some part, okay, to rely on unregistered design, which means that I won't be able to know if someone has infringed, or okay, just say I am a designer, I came up with this pen, okay. Now, I wouldn't actually know that I have infringed the design of somebody else. Why? Because one designer can make sure that all his parts are being protected. Everything can be protected here. So if I allow everything to be protected, or I allow certain parts, like what in the Oscula Science case, okay, Oscula Science case is actually a case about contact lenses, but they also use the teapot to explain. So the next question is, when we look at a teapot, so imagine a teapot in your mind, yeah? A teapot actually has the whole pot. It has the lid of the pot. It has the spout of the pot. It has the handle of the pot. It has the shape of the pot. You have the interior and so on. It has so many parts. So under CDPA, you can actually protect whichever part that you want to choose. And this is something that the CDPA actually allows you to do. So not necessarily you must protect the whole part. You may choose, you as a designer, you as the owner, you can choose which element, what element you want to protect, which element you don't want to protect. It is up to you. And this is a way that they actually make you or protect you even better under CDPA. I'll give you a better, easier example for you to understand. Now, if you have a car, you can choose which part of the car you actually want to protect. And why do they actually give you this? Is purely because they want to create certain sense of certainty and predictability. They want to be very clear and very sure on what you want to protect, or what you should protect, or what you may protect. Okay, so all this is something that is governed under the CDPA. Okay, we have the case of Sales and Stromberg as well. This is a case where the claimant actually, he came up with a chain. So you all know what is a chain, right? So this particular chain actually has a very geometrical shape of pendant. So this is a normal chain. This chain has a very geometrical shape of pendant. So this pendant is something that they were trying to rely on. According to the claimant, if you wear this pendant, you wear the chain with the pendant, it actually amends your aura, or it gives you a better, it throws negativity or something, some sort of thing that pendant can actually do. So the question that the courts ask themselves, if this plain geometrical shape of pendant can be considered as a design or not. And the court held that yes, a plain or any simple sort of geometrical shape can be considered as a design as long as it has a shape. Okay, whatever shape it is, as long as it has the shape, it can be a geometrical shape, or it can be an outward shape, or it can be a configuration shape, or it can be an article as a shape. Any part that you want, you may get it protected. Okay, so that is what the case of Stills and Stromberg has decided. And they said that if you have any geometrical shape, you want to get it protected as a design, and the courts will help that you can. Okay, So I repeat, this case is purely about the pendant, okay, that can actually heal your aura or remove negativity. And it says that it's a very beneficial if you wear that particular chain, okay. So this is what the court held. The question here arises is whether that particular pendant can be considered as a shape or not, and the court held that yes, it can be held as a shape even though it is just a very simple geometrical shape. So we are still looking, just to remind you all, we are still actually looking at design, okay. We are still looking on how to make sure that when you want to register, when you want to rely on unregistered design rights, your product or your article must be under design, okay. And this is the definition of design. This is what we have been looking all the while. We are seeing that what can be considered as a design, what cannot be considered as a design. So remember, I told you 5 very important things under unregistered design rights. That is design first, where we saw shape, configuration, or article. You must make sure your product is one of these. And then you look at basically originality. Make sure that this is original of yourself, not copied anywhere. And then you continue to look at this is a commonplace, design feel, and exclusion. So always keep in your mind, you must explain on these 5 things, okay? Yes, correct. It will, the burden will still be on the designer to explain. Okay. Now, the next thing I told you is original. So I told you originality is something that is of very important. You must show that your design is of original, commonplace, and design feel. So all these you will have to show. And section 213 sub 1 says that you must show your design is basically an original design. And what is originality? This is where we have the farmer case that have explained what is originality. On top of that, you must also show that your design is of commonplace, okay, and also feels within the design field, okay. So we will look at all this separately. Let's look at originality first. When we speak about originality, what is originality? So the Farmer Bill case have explained that originality is basically something that you didn't copy from people. So remember, I said independent creation. All this will show you that this is original. This is of my work. This is where I put in all my time, all my labor, all my skills, just like the labor theory, explaining that this is my work. I didn't take this from anywhere else. I didn't copy this. This is an independent creation. So this is what Farmer Bill case have explained. This case was decided in the Court of Appeal. Court of Appeal have explained what is originality. And according to Court of Appeal, originality purely just means that you didn't copy this from anyone or anywhere. Okay, as long as you can show this is an independent creation, you can automatically suffice for originality. But if you fail to show originality, automatically you cannot qualify for unregistered design rights. So originality is of very important. Okay, the next thing that we're going to look at is commonplace. What is commonplace? Commonplace basically means one thing, whether this is something that people know of or people don't know. So if people don't know, okay, just say if there is if I'm using the place that this is a common place, which means that it has similarities. If it has similarities, you cannot come and claim or want to claim your design under unregistered design right. So very important thing here is you must show that your design doesn't have a common place with the other designs. Okay, your design must be something which is very in relation to originality. You must show that your design is your own design. Your design is not a design that has been something out there in the relevant art. Okay, just say if you're talking about the design of the pen, your design of the pen is something that is not out there yet. If it is out there already, then the courts will decide that this design is of a common place. So you cannot suffice for unregistered design right. So you must make sure that your design is not commonplace, which means that not known of people yet. And we have the case of Farmer Bill, again explaining to us what is a commonplace. So according to Farmer Bill, if you want to know if your design is of a commonplace or not, you do a comparison here. Okay, you compare the both design and you see if there is any similarities to both this design. And this design, when you are doing a comparison, it has to be of the same field. Example, if it is not of the same field, then you cannot do the comparison. So let me tell you the Farmer Bill case first. Explain this Farmer Bill case to you. This Farmer Bill case is about a slurry machine. So what is a slurry machine? This machine is where they actually put in all the feces of domestic animals or pig or anything, any domestic animal like cow, pig, whatever domestic animals. This slurry machine is always usually in the farm. So they put in all the feces, and this machine is supposedly to separate between the solid feces and the liquid feces. Okay, so you know feces you put inside. This machine's duty is actually to separate the feces. So solid feces will be somewhere else, liquid feces will be somewhere else. What is the purpose of this machine? This machine came into account purely to fertilize the plant. Okay, so they can use these liquid feces to easily fertilize the plant, and then the solid feces can be used for something else. So this is the Farmer Bill case. The Farmer Bill case is about the slurry machine. Now the next question is, has this machine been copied or not? Okay, so in order to identify if it has been copied or not, the court said that compare both of them to see whether this sort of design has been out there in the relevant design field or not. If it has been there, then it is, of course, if it has been there, then it is of commonplace. But if it is not been there, doesn't have any similarities, then it is not a commonplace. So you must get this right, yeah? If don't have similarities, don't have anything of same, the claimant's design and the defendant's design don't have any similarities, then the courts will establish that it is not of commonplace. If it's not of commonplace, the next thing you forward and look at design field. If the courts feel there is some similarities in the same place that we are, example, in the same machinery field, if the court feel that this design is out there, you have copied the design, you have followed the design, then the court will say that, look, this is of commonplace. But, okay, remember that independent creation will not make the design commonplace. So if you can establish that, look, I actually created this design by myself. Though the design has been there, I didn't copy anybody. This design is totally out of what is there. Then, of course, it will not make up or be sufficient for commonplace. Commonplace will only be there if the courts find, and when they compare both the design, they find that there is some sort of similarities between these two. So if the court finds some sort of similarities, the court will feel that, look, we cannot protect you under unregistered design rights. Okay, we will look at the design field, the last one, before we take a break and look at exclusion. So the question is, does Oscula actually mention that individual parts could be a commonplace, but the combination must not be a commonplace? Yes, combination must not be a commonplace is something that Oscula has actually mentioned. Okay, so this combination all you put together and then you decide on commonplace. Okay, so the next thing we look at is design field. So how do the courts actually look at design field? Design field is one very, very general or very broad thing that the courts look. Why the courts didn't narrow this down under the Scholes case? The courts say that they didn't narrow this down because the courts find that if this was narrowed down, what will happen is basically okay, the whole idea of design rights, unregistered design rights, is to protect people, to not monopolize the whole system, right? Monopolize the whole parts, okay, whole design rights system. So if we really narrow this down in the design field, the courts find that the purpose of IP law protecting design rights will not be there. So design field is one thing that the courts take into account. So what do the courts do in design field? Just say you have a notional designer. So example, you have a notional designer. Just say all these designers are in clothes. Okay, I give you an example in clothes. So you take all these designers who are in clothes, yeah, and you ask them whether they have actually seen a familiar design in this design field or not. That is the question that the courts ask in design field. So in design field, the courts ask themselves is, take all the range of designer under the design field of clothing, and then you question them and ask if they have actually found a similar design in this field or not. So remember one thing very important when we discuss about design field is, do not make the design field, example, if you're using window, don't ask the window designer about the clothes. So clothes designer, you ask them whether this is something that they have seen, something familiar in their field, or they have not seen. If they have seen, then of course you will fail under design field. But if they have not seen anything familiar, they don't see anything similar, then this will definitely be something that will be protected under unregistered design rights. So under design field, you take a group of people, a group of designer which is in relations to the field. So if it's a field of clothing, then you get designers or in the field of clothing. If it's a designer of window, then you get certain designers of window, and you ask them the question of whether they have seen something similar or they have not. If they said that they have seen something similar like this in their design field, then the courts will establish that this cannot be sufficient for unregistered design rights. Okay, so again, these are the 4 things that we looked at. First, you must make sure that your design that you want to protect will have to be under the definition of design. And when we look at design, we look at shape, configuration, and article. The next thing is make sure that this design is of original. When we look at originality, make sure that this is something that you did not copy from. Okay, make sure that you didn't copy this from anyone. And how to know whether you have copied or not? You look at both of it and you compare. Make sure that, sorry, don't compare, you look at this and see whether this is an independent creation, whether this is something that you have created by yourself, this is not something that you have copied, and things like that. In commonplace is where you do a comparison. Okay, you compare the claimant's product and the defendant products, and do you see any similarities there? If you do see any similarities, then it is of commonplace. If you do not see any similarities, then it is of not commonplace. Okay, so you establish all this as you go, and then next you establish design field. In design fields, what Scholes window have said is this is something that we look at it very broadly instead of narrow. If we look at it very narrowly, then a lot of designs, unregistered designs, will not fit within this definition. So that is why they look at it in a very broad term or in a very general term. So they ask a lot of designers, they take a range of designers and they ask themselves that, look, have you seen any such familiar designs? Have you seen anything familiar? And if they have not, then most likely you can establish design field. Okay, this is in the Scholes case as well, they have defined that this is of a very general or broad approach. Okay, the next one, so once you have explained all this, okay, you have explained design, explain originality, explain commonplace, explain design field. Finally, you must make sure that your design that you are trying to register here does not fall within the exclusion, which means that if it falls within the exclusion, okay, if your design that you are trying to protect falls within the exclusion, most likely you cannot rely on unregistered design rights. And when we look at exclusion, we are going to see 4 things under exclusion. That is method of construction, surface decoration, must fit, and must match. So before we look at exclusion, we're going to take a 15 minutes break. So today we'll take a direct 15 minutes break. Now it's 4:15. So you come back at 4:30, and then we will continue looking at the exclusion under unregistered design rights. So let me tell you briefly, if your design fall within this exclusion, most likely you will not be protected under unregistered design rights. Okay, so we take a 15 minutes break, come back at 4:30, and then we will continue looking at the exclusion. Okay, let's continue at the exclusion. Yeah. Okay, so when I told you exclusion, what you have to remember is this four thing. Okay, the very first one is method of construction, surface decoration, must fit, and must match. So these four are an exclusion for unregistered design rights. So make sure that the design that you are trying to rely on under unregistered design rights does not fall within the exclusion. And the whole reason why exclusion came into account is purely because they don't want people to monopolize the market. So this is why they have exclusion. Now, how are we going to decide if there is an exclusion in the article? So I'll tell you this method. Just say you take the article in front of you. Whichever parts of the article which falls within the exclusion, okay, whichever that falls within section 213 sub 3, whichever that falls within the exclusion, you take them out. So example, if this cat falls within the exclusion, you take it out. Now you have this bottle, you have this design, example, you have all these are things that do not fall within the exclusion. Now you take this and you start the process of whether this falls within the definition of design, this has originality, has this commonplace or not commonplace, and then you look at the design field and then you decide whether this can be under unregistered design rights or not. This is what the case of Ultrafame has explained to us. When you have an article or when you have a product that has an exclusion in it, doesn't mean that the whole product cannot be under unregistered design rights anymore. You can. Okay, just say if I have this product, if this is just the exclusion, I remove the exclusion, the balanced product that I have, that is what I should use to decide whether it will be suffice for unregistered design rights or not. Okay, so this is the concept, or this is the approach that you use when you have a design that is within the exclusion. So having an exclusion in the design doesn't automatically disqualify the whole design. You just subtract from it the balanced design, you identify whether it is protected under unregistered design rights or not. So that is the approach that you use. So in your problem question, if at any point of time you find that, oh, this part falls within the exclusion, okay, then you remove that. You talk about the balance part of that article or product. Don't automatically feel that, oh, if there is an exclusion, meaning everything, the whole product cannot be used. That is not the idea. Okay, and when we speak about exclusion, okay, in the case of Coppinger and Scones in on the article of James on copyright. So what they have decided, or what they say, exclusions are only things that have been identified under section 213 of the CDPA. So whatever that has been listed, remember the four things that I told you: method of construction, method of construction, must fit, must match, and surface decoration. Only these four will fall within exclusion. If it is not within that four, you can product, or you can still get whatever that is in the product. Okay, so whatever exclusion that is listed under section 213 sub 3, that is what you should take into account to exclude. And I told you, right, what is the method of excluding? Remove the exclusion, balance product, you do. Just because the part of the product is in the exclusion doesn't mean that the whole product will not be able to register, will not be able to be protected under unregistered design rights. Okay, Now, in the case of Fulton Company and Grant, Barnett and Company, the claimant or the courts have held that if the claimant is actually trying to claim under infringement of infringement under unregistered design rights, it is very, very important that you be precise on what you are trying to get protection here. Why is it very important to be precise? Because remember, in the previous 2 slides, I explained that sometimes you can exclude one part and only talk about the other parts, correct? So because of this, it has to be very clear on what you are actually trying to rely on. Okay, which elements of the design that you are trying to seek for protection. Everything must be very clear. So now, example, I know this cap falls within the exclusion. So I omit this cap and I only look at this part and I say that, oh, this is the part that they have infringed my unregistered design rights. Okay, so you will have to be very, very clear when you are initiating a claim under infringement under unregistered design rights, purely because certain parts can be omitted. Remember, in the Oscula case, they spoke about the teapot, where in the teapot you have the lid, you have the handle, you have the whole pot, you have the and you have the whole pot. Like, just look at the whole pot. You have so many parts of it, and you have to be very clear in what you are actually trying to protect. And even when you look at infringement, be very clear on what have been infringed, because not necessarily everything or the whole part can be infringement. Now, method of construction. Okay, method of construction is something that I want you to listen to me carefully. Okay, what is method of construction? One thing you must remember when we look at design rights as a whole, design rights is basically about the appearance. Okay, you are not allowed to actually you are not allowed to protect the way that this design has been made. I give you an example. Yeah, if I use a certain method, okay, just say the method that I use is example. Yeah, I really don't know how they make this bottle, but I am just going to use an example that the method that I use to come up with this bottle is what I call the planting. Okay, example, but that's not the truth, because I don't know how they come up with the bottle, but I'm giving an example. So just say if I use a method called planting to come up with this bottle, the method that I am using, I am not allowed to copy, I am not allowed to get it protected under design rights, purely because we don't talk about the method here. When I am relying on unregistered design rights, my clear intention here is the appearance. If we are allowed to actually register the method I came out for this bottle, then people will start monopolizing the method. Example now, anyone using the method called planting to come up with any other product, just say they use the method called planting to come up with this phone, then I will claim under infringement straight away. Correct? So method or principle of construction is something that the courts will never allow under design rights, purely because they don't want designers to actually monopolize on the way that this particular article is being made. They only allow you to actually rely on the appearance. How is this done? What way does it look like? Only that the courts allow you. But there is a twist to this. Okay, what is the twist? These two cases, the case of Rolla1 and the case of Parker. Why is there a twist? But let me tell you first, okay, what is all about this. So just for your information, it's not called London, it's called London. So please correct the spelling is not London, it's Landor. Okay, it's not London, it's Landor. There's a spelling mistake there. Please correct that word. It's London and Howard International, where the courts have said that when you are actually looking at this construction, right, what is important is the question you ask yourself. Okay, you don't ask yourself how they achieve this. Don't ask yourself how they came out with this. How they did this is not the question. The question that you ask under method of construction or under design right is the appearance. Okay. So in the case of Rolla One, the court held that they deny protection for them. They deny protection, saying that we are not going to protect the way that you have put the folding arm, okay, of the machinery on the fuel tank. So the fuel tank is here. The way you put, okay, just say if you used a method, okay, if you use the method to put it, I will not protect that method there. Because if I allow you to protect that method, of course, I am actually trying to not allow any other designers to use that method, which will come back to the same basic where I said we actually have this whole idea of unregistered design rights because we don't want people to monopolize the market. We want people to also have other spare parts to come in, so we will have a fair competition there. We don't want to have unfair competition where we only allow one person to come up with all the products or all the spare parts, and the citizens will have to rely on this. Okay, this is what the case of Rolla One said. Rolla One said, look, method I will not allow. What I will allow is, if you're talking about the appearance, yes, can. Okay, so remember this, the way you create a product is something that will fall within the exclusion purely because they want to allow other designers to use the same method to create whatever they want. But design, appearance, yes, you can claim. Okay, so in the case of Parker, okay, you look at the last case first, yeah. In the case of Parker, the court held that stitching inside of the mobile phone was protected. So if you say stitching, this is a method of construction. Why in Parker the courts allowed was purely because the court said that we only allow because the only way you can actually attain this is through stitching. Okay, example, I'll give you an example. Yeah, let me just take out my phone case. Okay, so if you see the phone case, right? If you have your phone case with you, you can see usually they have like a method to stick these, they have a method to do this. So in Parker, the court held that if I don't protect, okay, then they won't have a phone case. The design of the phone case will be there. Okay, example. Okay, so they said that if this is the only method you can use, okay, this is the only method you can use in order to get the design, yes, I will allow. But if there is so many other methods, okay, example that if there's so many other methods, like in the case of Rolla One, placing the folding arm on the fuel tank, the court said that no, I won't protect this because if I protect this method you use, other people cannot put any other machine in any other places. So this is why in the method of construction or the principle of construction, the court held that if this is the only way, yes, you can. But if you have so many other ways, that, like example, like in the case of Rolla One, you can put it on the fuel tank, you can put it at the back of the tire, or anyway, you have a few other places, I won't protect. But in this case, in Parker, the court held that we will protect purely because this is the only method you can achieve only this one result. If I can only use this one method to achieve this one result, yes, you may. If not, you cannot. Other than that, Section 213 of the CTPA also allows you to protect type of materials. Okay. Example, in the case of Christopher Tusk, the courts allowed that the aluminium sliding in the wardrobe doors were actually not protected. Okay, they didn't protect this, but this will cover choices of material. Okay, you can protect certain choice of material. Like just say example, I am the one who is going to use aluminium. Example, I'm going to use aluminium in my microwave. If the court feel that this is one method that we should allow to be protected, the choice of material that I have used, the courts may allow. So anyone else uses aluminium in their microwave will be caught for infringement. Okay, so the courts do allow type of material. So in the case of Christopher, the court said that aluminium in sliding door were not protected, because the court said that if I protect this, then every other people cannot use aluminium in their wardrobe door. So that's why the court said we will not protect this. The whole reason is we don't want to monopolize. But remember, the general rule is choices over materials can be protected. In the farmer bill case, the court has the laminated rubber that is between the roller and the slurry separator was not protected. But in Parker and Tyndall, the court held that the stitching process was actually protected. So one thing you must always remember here is the way that you are trying to rely on unregistered design rights. Okay, what is the purpose? The court will see whether all this is going to monopolize the market. The main idea of unregistered design rights is to avoid monopolizing of the market. So that is their main idea here. Yeah. The other thing is what we call the must fit and must match. These two are exclusions under unregistered design rights. So under unregistered design rights, we have the method of construction. We have must fit, must match, and surface decoration. Must fit and must match is something that was that came up or that is in section 1 sub. So remember here, sorry, again, this is another mistake, is section 213 sub 3b. Okay, not 123, it's 213. So those of you who have your soft copy there, please amend this. It is section 213 sub 3b, which actually came out and said the exclusion for must fit and must match. Okay, please correct this, is 213. Yeah. So what is must fit and must match? Must fit and must match is actually a decision that was taken into account by the case of British Lanyard and Armstrong. So again, I told you all this comes into account purely because they want to allow manufacturers of spare parts to come up with their own design, not only rely on one design. Like if you have a Mercedes there, Mercedes filter or the Mercedes something you want to change, don't always have to be only something that is produced by Mercedes I can change. If we allow something like that, automatically it will be monopolized. So Mercedes company will start increasing their price as they like, and consumers will suffer. Okay, so we don't want this to happen. So because of that, if it is anything that is related to spare part, we want to have people to compete with each other. That is why must fit and must match came into the exclusion of unregistered design rights. So if your design falls within the exclusion of must fit or must match, automatically you cannot get it registered under unregistered design rights. Okay, remember, must fit and must match only applies to design rights. Okay, software, databases, or any other forms of copyright doesn't apply. Must fit and must match only applicable to design right, unregistered design right. So what is must fit and must match? Must fit and must match is one very complicating thing. I will tell you a very easy explanation first before we look at other cases. Must fit is an interference. You must have an interference. Example, I'm going to give you this pen. So you see, if I put this pen inside here, okay, this pen, two different things. I'm putting this pen inside here. I would call this as must fit. Okay. At the same time, this pen can be also must match. So that is why Coppinger has said that this must fit and must match is actually very confusing in nature. But of course, we have other cases that have made our life more easier under must fit and must match. Now, all you need to remember or all you need to think is must fit is an interference. When I want to put this inside, this whole part of the pen and this whole inside part of the cap is going to interfere with each other. Okay, so if I don't have this pen, if I don't have the cover, you must show that your design actually cannot function well without the cover. I'll give you an easier example. I'll give you this bottle. Now, we have this bottle here. Without the cap, does this bottle function? Yes, the bottle will function. I can still drink water from the bottle. But what is the purpose of the bottle? Is the bottle's purpose to drink water or to transport the water from one place to another place safely? So the purpose of a bottle is actually to transport some water from one place to another place safely. That is why we actually have a bottle. So now here, this cap, can you see inside the cap and outside here is where it must fit. There is an interference, or in other words, it must touch together. Okay, this part and this part must touch together. And if this part and this part is something that is touching together, it will fall within the exclusion of must fit. So again, remember spare parts. So if at all, what happens? Example, what happens? Yeah, if at all, I'm giving an example. If at all, now the bottle's cap missing. I lost the bottle cap. Okay. Now I need to buy this bottle cap. Of course, bottle cap is not something that is very easy to find something that is going to fit this. But I'm giving an example. Yeah, how they monopolize the market. If I lost this bottle cap, now, if I want to buy this bottle cap, the manufacturer of this bottle, who's this manufacturer of the bottle? I think it's E-Palas. Okay, I think it's their manufacturer. E-Palas will sell the cover for a very expensive price. And if I want to use this bottle, I must actually go and buy this expensive cover back because I've lost it. Buy this expensive cover back to use it. And only if I have these two that is going to function together, only then this bottle can be functioning together. Or a better explanation would be a thermos. You know, what is a thermos, right? Thermos is where you store hot water inside. Now, if you lose the cap of the thermos, do you think the hot water is still going to stay hot inside? No, it will not stay hot inside. So, because it doesn't stay hot inside, it will lose the function of the bottle. It will lose the function of the thermos. I cannot drink hot water anymore. And if I take out, you see there's interference, right? Connection, the connectivity of these two things. Okay. And only if I connect these two things, that would be considered as a functioning product that would fall under must fit. Okay, so this is what we look at must fit. Must fit meaning you must have connection. So you must show that the cover is connected to the bottle. You have to show that connection, and only with the thermos connection, the article, the thermos can function well. Okay, then that would be considered as a must fit function or must fit article. Okay, so primarily you look at two things when you look at must fit. You must look at the interference and you must look at the two things that is connected with each other. So we have the ultra frame case that have explained must fit. Must fit is basically anything that has a connection of interference. Like I told you, right? You have to use these two together. Only when you use these two together, you will make sure that this product is functionable. Why the court say must fit will fall within the exclusion? Because if you lose the cap of the thermos, you must go back to the same company to buy the spare part. And if you have to go back to the same company and buy the spare part, do you think that the spare part owner can monopolize the market? Whatever price he's going to put, that is what you have to buy. And this is where IP is always very worried or scared about consumer or manufacturers actually trying to monopolize the market. In order to monopolize the market, in order to avoid monopolizing the market, that is why they actually have this whole exclusion. So even when you lose the spare part, you can buy other manufacturers' spare part. You don't have to rely on one person's spare part, so you avoid the monopolizing of the whole IP rights. Okay, one thing that I want you to remember is in Must-Fit, we have two important cases. You have the case of Ultraframe, and you also have the case of Dyson. Okay, Dyson and Quartex. You can go and read if you have time. If you feel that you want to do extra work, you can go and read the decision of Dyson and Quartex, where you can see ManJ have actually come up with certain judgment on why or how interference is very important. So, of course, this case went up to the Court of Appeal. And in the Court of Appeal, we have Lord Justice Jacob, who have agreed to all the explanation that ManJ has given in his judgment in the case of Dyson and Quartex. So if you have time, go and read the judgment of Dyson and Quartex, and you can also see what ManJ has agreed to all his explanation on, especially on Ultraframe. Here is the principle that I have here. Ultraframe and Dyson have actually tell you the same thing, that when you are talking about Must-Fit, all that matters the most is basically the interference of the article. Whether they are connected together, only when they're connected, they work together. And then we have the Oscular Science case as well that have explained about Must-Fit. What did the Oscular Science case actually explain to you? They are trying to tell you that why or what is the reason or the public policy behind this Must-Fit feature. Because the courts, again, all coming back to where they don't want the consumer to be monopolized. They don't want the market to be monopolized. They don't want the consumer to feel like, oh, yo, I have to spend all my money to buy the expensive spare part. If you don't give competition, if you allow protection or you allow them to protect something of much, then of course it is going to have no competition. Everybody will have to rely on this one manufacturer, and he will decide the price in the market. The next question that also Oscular has actually questioned and asked, whether a human body, okay, so anything that is considered as a part of human body, and here when you speak about parts of human body, he's not trying to tell your hand, legs, and etc. He's trying to ask like contact lenses, gloves, are these all considered to be an article for the purpose of Must-Fit or not? And the courts have regarded that this will be relying on the public policy. If this is like contact lenses, like example, if they allow you to protect contact lenses, yeah, the shape of the contact lenses, the design of the contact lens, what will happen is nobody else can come up with the contact lenses. Only one market can come up with the contact lens, right? Glove. If just one person can come up with the glove, then the price that that particular manufacturer is going to come up with is going to be the price that is set in the market. So if he is going to say it's going to cost really expensive for the glove or the contact lens because he has the rights protected, then of course the courts will feel that it's unfair. Okay, because you will monopolize the market. And when you look at the Must-Fit feature or the Must-Match feature, right, or even the whole idea of the exclusion is purely on public policies. So if you are actually trying to rely on the exclusion, you will have to look on the way that you are actually trying to, the public policy behind that. So as a very good lawyer, what matters or what is the most important thing is the way you draft your case. Okay, if you are going to draft your case in a way that you're going to say that this is of course going to infringe the public policy, okay, then of course most likely you'll fall the way that you're going to argue, okay, the way the claimant is going to argue in the case of whether this is of public policy or not. Okay, the next thing is when we look at must fit, how important that this or how precise that this must fit within this is the next question that we ask ourselves. Whether the must fit feature, whether it has to be very precise in nature or just of a very sufficient, okay, is enough. Okay, that is the question that we ask ourselves. In the case of ammonia, the court held that breast photosynthesis, okay, in this case, they held that the exclusion did not apply. Okay, why the exclusion did not apply? Because in breast photosynthesis, you can have a few numbers of different bras actually trying to fit this. If they allow the exclusion, it will be difficult. So that is why the exclusion did not apply here. But if you look at the next case, okay, you look at the case of ammonia, or sorry, if you look in the same case, in the case of ammonia, they have come up with a clearer definition or clearer explanation on what must fit must mean, or what does must fit define. So they said that, you know how is a rigid plug and a socket? You have one plug, you have socket, right? The socket has different types of socket. Not all the socket is the same, correct? So this is a better explanation of must fit. Okay, so if the socket is in this way, you have to put it in this way. That is a better way to find out whether how precise the must fit must be. Okay, the must fit must be something that is very precise in nature. Only if very precise in nature will fall within the must fit. But if you have so many different things, then it will not fall within the exclusion of must fit. So that is why in this case of ammonia, the court held that you could fit so many different numbers of bra. So that is why the exclusion here did not apply. Okay, this is the case that I told you again, Dyson's and Quatalex, where I told you to go and read the decision of Lord Justice Mann and all that, right? So I'll tell you very briefly what happened. Here, very difficult for me to explain the spare parts, but I will tell you what happened. Here, Dyson actually claimed or brought a case against Quatalex, saying that they have come up with some spare part that is very similar to the design of Dyson. Okay, so this is what Dyson said. Dyson said that these Quatalex have actually come up with a design that is very similar of the design that Dyson has. Okay, so Dyson sued Quatalex, saying that how can you actually come up with a design that is very similar like mine? So this is what happened in the case of Dyson and Quatalex. So they were talking about some spare part that was inside. Okay, then what the court held that the important thing when we talk about must fit is you as a designer, actually you have the right to choose the way that you can fit the interference. Okay, the matter here is when we look at must fit, okay, the most important thing is the interference of the must fit. And if it is not fitting, doesn't fit, you come up with some other design, doesn't fit with my interference, it doesn't matter. Okay, what matters the most when we talk about must fit is your, now just example, yeah, I come up with this example, this cap. Okay, I'm coming out with this cap. This cap definitely is not going to fit with this. Okay, doesn't fit. How can I put this inside this? When it is something that is not fitting, doesn't matter. What matters if you want to fit within the exclusion of must fit is basically you must show that it must fit within. It has to go inside. And when you talk about this, also very important for you to show the way that you can fit it inside. If the design is something of separate, but similar design cannot fit within your spare part, doesn't matter. Okay. Okay. The case of Fulton also spoke about must fit, where they were talking about a folding umbrella. What about the folding umbrella is where the court said that if I allow so many, if just example, an umbrella to fold, yeah, if I allow this to be protected, okay, this way to be protected, what will happen is nobody can come up with a folding umbrella. Only one person can come up with a folding umbrella. So now I hope you get a picture of why the courts always will take into account of whether this must fit is important to fall within the exclusion. If it is going to be fitted, okay, then of course you cannot register this under unregistered design rights. It will have to be under the exclusion of unregistered design rights, purely because they don't want you to monopolize the market. They want to make sure that they have a certain people or a certain amount of numbers of competitor to make the price in the market stable. If we allow one person alone, the courts will often find that people can monopolize the market very easily. The next thing that we need to talk about is the must match feature. Okay, what about the must match feature? The must match feature is where it contains in section 213B2, okay, where it is very similar with the nature of must match. I'm not very similar with the nature of must match, very similar with the principle of must fit, where the main motive here is to avoid people to actually monopolizing the market. Okay, this whole idea of the exclusion is basically because they don't want to monopolize the market. So here, when you look at must match, yeah, what is very important here is the integral form. So I'll give you an easy example. Okay, the example here would be a car. Why I would use a car? So when you look at a car has so many parts to the car, correct? It has the steering wheel, it has the rear mirror, it has the side mirror, it has the door, it has the seat, it has the bonnet, it has a lot of parts in the car, right? When you talk about must match is always connectable to the sale of the product. Okay, I repeat, when we talk about must match is always very connected to the saleability of the product. Why saleability of the product? I will tell you. Now you have a car. Okay, so when we saw must fit function, just let me remind you, when we saw must fit function, it is very important that you show that if without this cover, the thermos cover, the bottle's function will not be there. The function is very important. Interference is very important. But when we look at must match, what is the important key point here is integral and dependent. So now just say we have a car. Okay, would you want to buy a car that doesn't have a door? Most likely not, right? Why would you want to have a car that doesn't have a door? So the next thing you ask yourself, is the car still functionable without the door? Yes, you can still drive the car even though there is no door in the car. You can still drive the car, not an issue, no problem. Okay, so you satisfy that. Now, what is different when the car doesn't have a door? People won't buy. Saleability is not there. You cannot sell the car. And the appearance of the car Why would somebody actually buy a car that doesn't have a door? So when we talk about must match, the most important thing here is the dependency of the product. If the product is very dependent onto the car, that product will be called as an integral product. That if this car doesn't have the door, people would not buy the car. Okay, so of course you have a car, you can still drive the car without the door, but what will be affected is the safety and regulation of the car. Of course, the car will not be safe enough, but the car will still function like normal. Doesn't have a problem with the functionality of the car. And this is where, when you see it doesn't really affect the functionality, then the exclusion will be under must match. So must match, always remember one important thing is the appearance of the article. The appearance of the car will be changed. People will not like to buy the car anymore purely because they feel that, oh, the car looks so ugly. How can I sit down in the car? But the car still can function like normal, okay? So the article can still perform, but, okay, without that article, the saleability of the car will be reduced. Okay, so this is what you will need to prove under must match. So we have the case of Dyson. Okay, we have the case of Dyson and Quartex here who have explained on the reasons of dependency. What is dependency? Dependency is where we look at the value of the judgment. What would a person think of the car's price? Now, a car that has 4 doors, most likely you will buy the car for a higher price. But if the car only has 2 doors, okay, behind 2 doors they don't have, most likely the value of the judgment here will not be high anymore. People would not be willing to pay so much of money to actually buy the car. So this is the whole idea on defining dependency under must match. So when we talk about must match, the courts will look at whether this item is dependent on the other item or not. If the item is dependent, then for sure that the saleability will reduce. Okay, and because the saleability will reduce, the next thing the courts ask themselves is whether the shape and the configuration of the car is changed or not when you don't have this item. Yes, when we look at the car door, if the car door is not there, the shape of the car is not the same. The configuration of the car is not the same. The design of the car is not the same anymore. So when you have a particular article that is not the same anymore, okay, if you take out the car, you take out the door, doesn't be the same anymore, then that will fall under must match. Okay, we have the case of Mark Wilkinson, who have also explained on the part of integral part. Okay, what integral part? He said that this whole exclusion, if you're talking for the fitted cabinet by a whole, cannot. Okay, when you're talking about the fitted cabinet, okay, this will not be applicable purely because the cabinet is not an article. Okay, but when we're talking about a series of matching, like just say we're talking about connection of integral parts. Okay, just say you're connecting one part to another part, then this form of matching things, whether it is important or not, is it important to ask the question of integral? So the main idea of integral is basically when the designer is creating this design, when he's creating this design of the car, okay, just say an example, or even if the cabinet, when he's creating this design, is it that in his mind, he asked himself that this is the most important part of my design. Example, if I am creating this design of the bottle or the design of the car, is my um, is my car door a very important part, or is it not an important part, is what the designers should ask themselves. If they feel that this is a very important part, then that will automatically be an integral part of the design. But if they find that this is not a very important part, then that would not be an integral part. So here, first thing, when you want to look at must match, okay, you must see whether it is an integral part, and we look at dependency. So when we look at dependency, we look at Dyson, just like the same car thing. Use the car as an example always when you want to talk about must match. Okay, think whether it's a car door. Of course, the car door is dependent. Okay, the car door is what forms the integral part. Why would a designer come up with a car that doesn't have a door? It wouldn't make sense. Why would a designer come up with a car that doesn't have a door, right? So this is what very important. And when you talk about must match, rather than the functionality, like I told you, the car door not there, the car still can run, but must fit. If the thermos flask is not there, the whole thermos cannot be used. When we talk about must match, all you need to remember is the salability, the appearance, whether it will disturb the appearance or not. We have another case, the Re-Ford Motor case, which have done a very clear explanation. So if you see must match, we don't really have a lot of case law that is explaining must match. But we have the case of Re-Ford Motor, which have actually explained in a bit further of what must match must mean. So if you see the last point, the second point in Re-Ford Motor, yeah, steering wheel, wing mirror, wheel cover, these are not considered to be an integral part. Why? This is purely because this is a subsidiary part of the car. If now I come up with the creation of the car, I can always change the steering wheel. And when I change the steering wheel, it doesn't give much of an effect to the appearance of the car. The car would still be the same. Now, the other way that you can think of is substitution. Just say, if I substitute the car door, you will look, the appearance of my car will change. But if I substitute the steering wheel, the appearance of my car will not likely change. It will still look the same, because integral parts are things that are very, very important to the appearance of the car. We know that the body panel, we know that the door, we know that the bonnet, the grille, the boot bumper, the instrumental panel, the spoiler of the windscreen, all these are considered as a dependent product or a dependent article, purely because if you change this, yeah, if you change this, automatically what will happen is the car will lose its integral part. The car will look different. When the designer comes out with a design, what matters the most for the designer is basically the whole part, the appearance of the car is what the designer look for. So this is what we look at for must fit, must match. So we saw method of construction. Okay, method method, you cannot actually try to register under unregistered design unless if that is the only way, one and only way you can use to get that particular product. Under Parker case, the court held can. Okay, in Renovol, the court held cannot, because the court said that we don't acknowledge anything to do with method, because we purely look under design rights purely for the design of the article. And then we looked at must fit and we look at must match. Must fit, always remember interference is very important. If the interference is not there, then automatically you cannot use the product. Then we talk about must match. Okay, must match is where you talk about the saleability of the product, or where you talk about if I don't have the car door, the appearance of the product will look different. Okay, then it will fall within must match. Small items, of course, like subsidiary items, like how in the case of Reford, they have that steering wheels, wing mirror, wheel cover, these are all subsidiary items, so they are not integral, they are not dependent. Okay, when we look at must match, we must look at dependency is one very important thing. The last exclusion is what we're going to look at, surface decoration. What is surface decoration? But if I think the car doors are integral part of it. But, okay, I tell you, but if these sort of things are protected, right? These sort of things are fall within the exclusion, all comes back to, that means that you must only be able to buy the integral parts. Where if now just say my car door is missing, okay, I can only go back to that particular manufacturer to get it. One thing you must remember, must fit, okay, is something that always relied on. Must match is very less relied on. Must match is all about the saleability of the item only. Okay, so of course, when we look at integral part, a car door is an integral part. But again, the courts look at what is an integral part. Is it an dependency or not dependency is the question that the courts ask. And in must match, one thing that you must remember is, if without the car door, can the car still function like normal? It can, right? You can still move the car. The only issue here will happen is you don't have the safetiness of the car, which means that you cannot drive according to the rules and regulation of safety. You're not supposed to drive a car without the door. But other than that, the car is allowed to function properly. The car can still continue its functionality. So here what the courts look at is what is the integral part. Okay, so if they find this to be integral, okay, I think what you are saying is, if they find it to be integral, then it should not be excluded, correct? So this is exactly what the court said. The court said that if the designer finds that this particular article is dependent, yes, the appearance is the most important thing to be protected under design rights. Correct. That is the most important thing that the courts actually look at. Whether we should get this protected, the appearance is of course the most important thing. But if we allow all appearance to be protected, okay, under must fit and must match, right? This will be an exclusion. Okay, why again this is exclusion? Because they don't want to allow you to monopolize the market. So if it is an integral part, okay, integral part, you must allow it to be what we call the dependency. Okay, yes, correct. So must match exclusion actually should not apply if it excludes the part that constitute the designs of the article. So what is designs of the article is what we look at, what is important of the product. Okay, so now I'm giving you an example, integral part. Yeah, integral part is where it is of importance. So we talk about saleability. So always when we talk about must match, we look at the saleability of the product. Okay, so just say that if we have a car, okay, just using the car, the door of the car, if we don't have the door of the car, okay, just say the car doesn't have the door, the functionality of the car is still normal. It is still there, but the saleability will reduce. So that would be considered as an integral part of the product. So when you look at integral part, okay, what is very important is things that actually brings a difference to the car. Okay, so example, like I told you, right, the steering wheel. These are things that are not of integral. Like it doesn't really matter if it's there or not there. So this will fall within the not integral part of the car. Integral part means things that are very important to the car, things that makes a lot of differences. So example, somebody would not buy a car that doesn't have a good thing. Okay, no problem. Okay, so example, yeah, if just say you have a car and the car doesn't have a proper door, that would be a must match. So the thing that you must keep, the general rule of must fit and must match is just one thing. Okay, must fit meaning if this item do not fit within it, you cannot use it. Okay, let me just explain it again. Yeah. Okay, so we look at the basic definition. Okay, when we talk about must fit is something that you must connect that particular thing to the bottle. So just say you have a thermos, so you have to connect the cap of the thermos to the bottle, and only when I connect this integral part, this connection is there, that only then the thermos would function properly. Okay, so that would be falling under must fit. So when we talk about must fit, you must show that there is an interference. Okay, there is an interference, the inside of the cap and the outside of the cap. You must show an interference, you must show a connection. So therefore, you can say that this is must fit exclusion. Okay, so must fit exclusion, you must have both of them connected to each other. When you talk about must match, okay, so of course in must fit you have the case of Ultrafame where you say that the interference is very important. When you talk about must fit, you must talk about the whether articles of the body like the contact lenses, the gloves, all these are an example. So when you talk about must match, okay, must match is where you talk about the dependency of the product. Doesn't matter if the product is still functionable or not. Okay, example, like I told you the car, right? Okay, like example, I told you the car. What is very important is in the car, as you're driving, you can still use the car as it is, though you don't have the door. And must match is not something that is often relied on. So you don't have to worry much, because you will see later on when I explain to you in few other judges, right? Few judges will feel that must fit and must match is doesn't suppose, just like how you feel, shouldn't fall under the design, right? Shouldn't fall under this exclusion. So many different judges will also feel the same. They will feel that this exclusion shouldn't fall within this, because purely when you talk about design rights, it's all about appearance. Just like what you have explained under the chat, that is exactly what so many other judges will say. They'll feel like this must fit and must match is not supposed to be there. Okay, but we will look at that in your next class. Okay, so I will explain to you again must fit and must match in your next class. Don't worry much. Okay, maybe there's too many things that is in your mind. So during your next session with me, which is tomorrow, I will explain to you again must fit and must match, so to get a better understanding for you. And we will look at a few judges criticizing the whole idea of must fit and must match. Okay. Okay, and you have any questions further to this, you can always keep your question and ask me tomorrow in the beginning of the class. Till then, I will see you tomorrow at 9:30 a.m. Thank you.